Unmute yourself and show your face. Whoever is Hannah should unmute yourself. I need to see your face. I can't see you. I can't see the iPhone connecting as well. Unmute yourself. Counsel, you can't dress like this before the court if you are the one appearing in this case. Call the case, please.
In the National Industrial Court of Nigeria, holding at Abuja Judicial Division, before His Lordship, Honorable Justice Oyewumi, 7th June 2022, case number NIC/ABJ/220/19 between Joseph Agbo Okanga. Joseph Agbo Okanga and Mrs. Stella Ike and another.
Who is in court? Is there any party in court? Is there any of the parties in court? Learned counsel.
Maybe they are finding it difficult to connect.
I can see someone here online. I can see Hannah. If you have connected, please announce your appearance. I'm waiting for you. Two counsel are here, but we're having problem. I can see someone now. Is that a counsel for the claimant or for the defendant? Is that counsel for the claimant or defendant? Learned counsel, please talk to the court. Learned counsel.
I sincerely apologize to your lordship. I have a bit of challenge with my network.
Okay, who are you representing?
I'm representing the claimant.
Announce your appearance.
Okay. May me noble all be pleased. I am Douglas Ondo. Ondo is O-N-D-O-R, sir. Ondo and arrow at the end, sir.
Very well. You are for the claimant? Any other appearance
for the claimant?
Yes, I initially saw one, Hannah. I don't know.
Yes, sir. Yes, sir. She's the
who-
representative of the claimant who is unable to join the proceedings.
Claimant cannot be represented by anybody. Claimant is not a company. It's a natural person.
As court pleases, sir.
So it's either it's in
As court
court or
pleases, sir.
not. So the defense is not represented. Not
As court
registered
pleases.
defense counsel.
As
Sent
court
me.
pleases, sir.
Okay.
Even the claimant counsel received the message before he called me.
New for the defendants.
Me, my lord.
The judgment is ready and I'm going to deliver it. The defendant having been served with a hearing notice for today's business. We obtain a clean copy hereafter. This is the judgment of the court. By a general form of complaint filed by the claimant dated 31st of July 2019, praying the court for the following reliefs. Please mute your phone, learned counsel. Please mute yourself, mute your phone, mute your system. I don't want to hear any background noise. I'll take it again. By a general form of complaint filed by the claimant dated 31st July 2019, praying the court for the following reliefs. A declaration that the defendant's deliberate refusal to pay to the claimant his monthly arrears of salaries entitlements from 2016 to 2018 is unlawful, unwarranted, wrongful, and void. B, a declaration that the claimant is entitled to the arrears of salaries for the period he worked for the defendants in 2016 to 2018. C, an order of this honorable court directing the defendants to pay to the claimant forthwith the arrears of salaries owed to him between 2016 to 2018, totaling a sum of 820,000 naira only. D, cost of this action assessed at 1 million naira. E, interest of 10% per annum on the arrears of salary owed by the defendants between 2016 to 2018, from the date of judgment until the full and final liquidation of judgment debt. F, the sum of 5 million naira only as general damages, the general and aggravated damages. And G, such order release, which is an omnibus prayer. It is the claimant's case that he was employed as a chef. He was employed as a chef by the defendants in October 2015 to provide culinary services to them at their residence at number 9, Adamuata Close Zone B, National Assembly Quarters, for a salary of 40,000 naira per month. He averred further that the defendant do not often pay his monthly salary as at when due, but would sometime owe and pay him a lump sum for the months he owes into his Union Bank account number with the name Okanga Joseph Agbu. He stated further that the defendants paid him the sum of 260,000 naira only as money owed to him for the month of January, February, March, April, May, June, and first 2 weeks of July. He equally averred that the defendants still owe him the remainder for the months of June 2016, as well as salary for the months of July, August, September, October, November, December, despite making several demands to the defendants, but to no avail. He continued that in 2017, the defendants were further indebted to him for 8 months from May to December 2017, as well as January to May 2018, before he was disengaged by the defendants without paying outstanding salaries of 720,000 naira only. He pleaded that the second defendant paid some certain amounts into his account as follows: 3rd March 2017, 200,000, 18 April 2017, 40,000, 23rd November to November 2017, 200,000, 22nd December 2017, 100,000 naira, 8 March 2018, 100,000, 19th March 2018, 15,000, 9th April 2018, 200,000 naira. He averred that some of the money were meant for other purposes, which the second defendant instructed him to carry out. He stated that in pursuit of the outstanding salaries, he approached the Human Rights Radio and Television Program, Berekete Family, to intervene in the matter. The first and second defendants filed a joint statement of defense on 16 September 2019, wherein they averred that the claimant has never been their employee, as there was never an employment offer, neither was there a termination of the said employment. They equally averred that the second defendant has never paid his salaries at any time as claimed by the claimant, and as such, they do not owe him any outstanding payment of the months of June to December 2016, and also 2017 and 2018. They equally stated that they do not owe the claimant the sum of 720,000 naira or any sum whatsoever, neither as salary arrears nor for any reason whatsoever. They however noted that the money paid into the claimant's account by the second defendant were donations out of their sheer human kindness as a result of the claimant's constant plea for financial assistance until they discovered the dark and sinister intent of the claimant. They averred further that the so-called Berekete family did not contact them at any time for any reason whatsoever. He stated that the claimant requested for assistance for his father's burial right, which they paid the sum of 200,000 naira, that they also donated 15,000 on the 9th of February 2018 for rent, 31,000 naira on 15th of May for relocation of his relatives living in flood-prone areas, another sum of 100,000 on 8 March 2018 after falsely represented to the second defendant that the initial transaction of 100,000 was not successful. Also 5,000 on 19th of March 2018 for feeding, and another 15,000 for flood disaster on the claimant's apartment. They also stated that the claimant came to the defendant's residence sometime in
was mistaken, muted.
Sorry, me noble lord. Sorry, me noble lord. Your device is muted. Your device is muted, sir.
Okay. So can you hear now?
Yes, sir. Yes, sir. We thank your lordship.
Very well, thank you. On the 25th of November 2021, one Mr. Akman Elijah Bani testified for the defendants. He adopted his witness statement on oath before the court as is evidence in this court. In this case, he was subsequently cross-examined by the claimant counsel. He didn't tender any documents. In compliance with the rules of this court, learned counsel filed their respective final written addresses. Learned counsel for the defense filed and raised a sole issue, which has been reduced into the body of this judgment. Then the learned claimant counsel equally filed, and I have reduced that also into the body of the judgment. The defendant in response filed a reply on point of law, which has equally been captured into the body of this judgment. So I will now go straight to the decision of the court.
Oh, please.
Upon an in-depth examination of the processes filed by the parties, the supporting documents, their respective written submission, it is my respectful view that the sole issue that would best resolve this case is whether or not the claimant has proven his case to be entitled to the relief sought. I would like to address the testimony of DW on record, that is Elijah Akpanbani, who testified on behalf of the defendants on the 25th of November 2021. He adopted his sworn deposition of 6 September 2019 as his evidence in this case. He did not tender any document as argued by the claimant counsel, but was cross-examined by counsel for the claimant. I will hereunder capture some pertinent parts of the cross-examination and DW answer to questions posed thus. He was asked, "You were not responsible for the payment of salary of the defendant's staff?" And he answered, "Yes." He was asked again, "I put it to you that all that you deposed to are information we were told by your principal, the second defendant?" And he answered, "Yes." Just a minute, please. And he answered, "Yes," unquote. It is obvious from the above highlighted questions and answered by DW that his evidence before this court is hearsay evidence, as he clearly admitted under cross-examination. The law frowns at such evidence as it goes to no issue. Now, Section 37 of the Evidence Act 2011 provides that, I quote, "Hearsay means a statement, A, oral or written, made otherwise than by a witness in a proceeding, or B, contained or record in a book, document, or any record whatever, proof of which is not admissible under any provision of this act, which is tendered in evidence for the purpose of proving the truth of the matter stated in it," unquote. Clarifying what amounts to hearsay evidence, the Supreme Court in the case of Abayomi Olalekon and the state citation captured Caribe White, GSC of blessed memory, postulated those, and I quote, "It is well established law that the evidence of a statement made to a witness by a person who is not called as a witness is called hearsay, if the object of such evidence is to establish the truth of what is contained in the statement," unquote. It is a statement made by a person while giving oral evidence in the proceedings as evidence of any fact stated. See the case of Akin Bino and Nigeria Army citation capture, the case of Adegoke and others versus registered trustees of Catholic Diocese of Ondo State and others citation equally captured. In effect, hearsay evidence is the evidence of a witness who is not giving evidence of what he knows, he knew or did personally, but of what he was told by another person. Such evidence will be rejected as hearsay. It is crystal clear by the testimony of DW on record that all that is stated on oath is the evidence of what the second defendant, his boss, told him. Such evidence, the law is right, cannot be of any judicial value to the court. It is in the light of this that I consequently reject DW's sworn deposition of 6 September 2019 as same is hearsay evidence. Having said the above, it is thus evidently clear that the defendant did not prefer any defense to this suit. They neither testified nor tendered any documents. It is a well-settled sound principle of law that pleadings, however strong and convincing the averments may be, without evidence in proof thereof, goes to no issue. Evidence is required to be led to prove the facts relied on by the party or to sustain allegations raised in the pleadings. In other words, an averment of facts in the pleading is not evidence and can never be so construed. The facts so averred must of necessity be proved by evidence except those facts admitted by the adverse party. It follows, therefore, that pleadings do not constitute evidence, and where such pleading is not supported by evidence, either oral or documentary, as in this present, it is thus deemed to have been abandoned. See the case of Ayo Buadi and Ujo and other citation captured, the case of Eze and Ene and another citation provided, the case of Olokunlade and another versus Samuel and other citation also provided. The import of this is that the claimant, though, by his declaratory reliefs, has the onus of proving his case. However, with the state of the defense hearing, all he need do is minimal proof. It is on that premise that the court is to consider the claimant case. It is equally important for the court to make a comment on the inelegant manner Leonard Defense Counsel made his submission in the final written address. The specific case in point is paragraph 2.22 of his final written address, where he stated as his last sentence, thus I quote, "We rely on the cases of," unquote. Here, counsel did not cite any case. It appears that counsel slipped into another realm at this point in time, forgot about the name of the cases, and probably wants the court to supply the names of the cases. This is a clear case of tardiness and display of lackadaisical attitude to this case, exhibited by both the defendants and their counsel from the commencement of this suit, as noted by Leonard Claimant Counsel in his final written address. Counsel appearing in a matter before the court should see themselves first and foremost as officers of court and refrain from imposing on the court the task of sending it on a wild goose chase. As it stands now, judges are more often than not overburdened with undeserved duty of ironing out the greases in some legal presentations that ought ordinarily to be rejected, but for the interest of justice and altruistic consideration for litigants. This practice is to be deprecated by the court. Now to the cross of this case. The claimant by his beliefs 1 and 2 contended that the defendants deliberately refused to pay him his monthly arrears of salaries or entitlement from 2016 to 2018, and that is unlawful, unwarranted, wrongful, and void, and that he's entitled to the arrears of salaries for the period he worked for the defendants in 2016 to 2018. It is the claimant's argument that the defendants were indebted to him in the sum of 720,000 naira for the months of January, February, March, April, and May 2017, as well as the arrears of salaries owed for the year 2016 and equally from January 2017 to May 2018. The defendants averred that they were never and not indebted to the claimant to the tune of 720,000 or any sum of money whatsoever, as the claimant was never their employee, saying that there was no termination since no employment existed in the first place. Now, the pertinent question to ask from the circumstances surrounding this suit is, was there any contractual relationship between a claimant and the defendants? Excuse me. Owing to the fact that there was no employment letter given to the claimant. In an action for payment of salary of this nature, it is necessary for the claimant to establish his employment relationship with the defendants by pleading and tendering evidence his letter of appointment. However, where there is otherwise ample evidence, either documentary, oral, or implied, to establish that there was an employment relationship between the parties, failure to tender the said employment letter would not necessarily be fatal to the claimant case. See the case of Savannah Bank Nigeria PLC versus Fakokun, citation captured. The case of Kaduna Textile Limited versus Umar, citation also provided. By the provision of Section 91 of Labor Act, contract of employment is, I quote, an agreement, whether oral or written, express or implied, whereby one person agrees to employ another as a worker, and that other person agrees to serve the employer as a worker, unquote. Still the case of Yeri and Bendel Feed and Flour Mill Limited, citation captured. Although the Labor Act mandates an employer not later than 3 months after the beginning of the worker's employment to give a written statement containing the terms of employment which will represent the contract between them. In this case, however, the defendant failed to give the claimant any written terms of employment. How then can one determine if there was any relationship between the claimant and the defendant in this case in the absence of a written contract as stated supra? The claimant in this present case stated that the defendants at the start of the contract used to pay his salary into his bank account, but sometimes pay cash to him. He tendered his bank statement to substantiate this assertion. Exhibit J is his Union Bank statement with account number 0037820276, dated 1st of May 2019. It is clear from the document tendered by the claimant that the sum of 40,000 naira he pleaded as his monthly salary was paid for few times and not regularly paid. He also pleaded in paragraph 6 of his statement of facts that the defendants often do not pay his salary as and when due, but will owe and pay him later in lump sum for the months owed. I find from Exhibit J that there are different times when the second defendant did pay different sum of money into claimant's account, ranging from 40,000 naira, 200,000 naira, 100,000, 31,000 naira, 100,000, 15,000, and 20,000 naira. All these means that there was an employment relationship between the claimant and the defendant for which the second defendant paid certain sum of money into his account as salary. Testimonies of CW2 and 3 under cross-examination who also averred that they were former staff of the defendant and equally show that they were not given employment letters as well. It is worthy of note that it is the practice of the defendants not to issue letters of employment to their staff in order to discard them whenever they want without paying their salaries. The defendants admitted of paying some monies into the claimant's account, but stated that they were rendering him financial assistance. They, however, failed to tell the court their relationship with the claimant for which enabled them to give him money as assistance. If I may ask, what was the basis for giving the claimant money? Is it as parents, brother, uncle, or a good Samaritan, or father or mother Christmas? All these questions remained unanswered by the defendants. It is in view of the facts and circumstances of this case, as well as the testimony of the claimant and CW2, which corroborates the testimony of the claimant, that I disbelieve the defendants and find in favor of the claimant that those monies paid by the second defendant into his account were meant for his salary for work rendered as a chef. It is tried that admitted facts need no further proof. See the case of Idigbe and Attorney General of the State, citation captured, the case of Edokpolo and Company versus Ohenhe, citation captured. The defendants admitted that they paid money into claimant's account, and that is a cogent proof that there was a master-servant relationship between the claimant and the defendants. It is upon this premise that I find that the claimant was an employee of the defendants, and the monies paid into his account were for the services rendered to them by the claimant as a chef from 2015 to 2018, I so hold. Having held supra that the claimant was an employee of the defendants and rendered services to them, by ILO Convention number 95 on Protection of Wages 1949 is a convention ratified by Nigeria, specifically Article 12, 1 and 2, provides that wages shall be paid at regular intervals. The intervals for the payment of wages shall be prescribed by national laws. Now, Section 15 of Labor Act, which is the national law here, provides that wages shall become due and payable at the end of each period for which the contract subsists. See the case of Mr. Sule O. Usman versus Union Bank of Nigeria PLC is an unreported suit number NICN/LA/56/2012, judgment delivered on 21st of May 2014. It was held in that case that employer's action of non-payment of salary of the worker as and when due, as in this instant case, was contrary to Nigeria's international obligation under the ILO Convention and the Labor Act. It is in the light of this that I find that the claimant is entitled to his arrears of salary for the period he worked for the defendant, I so find and hold. The claimant contends that is entitled to be paid the sum of 820,000 naira only as arrears of salaries owed to him from 2016 to 2018. It is clear, it is the law that he who asserts must prove. The onus is on the claimant to prove that he is so entitled on the preponderance of evidence. Either the onus is on the claimants to canvass cogent, credible, and verifiable evidence to prove his claim, for 820,000 naira. See the case of Union Bank versus Rabi Abdul and Co. Limited, citation captured. The case of ACB and Ufondu, citation also provided. It has also been held in several cases by this court that a party who claims entitlement has the burden to prove his entitlement to the sum claimed. Say the following cases in which judgment was delivered by this court: Suraju Ufai and Bureau of Public Enterprise and Orders, suit number NICN/LA/18/2013, judgment delivered on 4th of June 2018. The case of Mohammed Dungus and others versus ENL Consortium Limited, citation captured. The case of Peter Demenge, Kumba and Dar Communication PLC on reported suit number NICN/ABJ/25/2020, a judgment delivered on 3rd March 2021. The claimant's monthly salary as evinced in his pleading is in the sum of 40,000 naira, as corroborated by his account statement as BJ. A perusal of the account statement coupled with his averment in his statement of facts and means that is owed 6.5 months in the year 2016, which amounts to the sum of 260,000 naira. That is for the months of July to December and half of the month of June. I'm thus satisfied by the evidence before the court that the sum of 260,000 remained unpaid by the defendants to the claimant. Accordingly, the claimant should be paid 260,000 naira for the 6.5 months in 2016.
Score, please.
Now for the salary from 2017 to 2018, claimant has to prove two things. First, he has to show the court not only his entitlement to the said claim, says a sum claim, but also how he came by the quantum of the sum claimed. His claim is in the realm of special damages and has to be specifically pleaded and strictly proved by the case law authority of NNPC versus Cliffco Nigeria Limited, citation captured. The Apex Court held that special damages will not succeed simply because it was admitted by the other party. They are unlike general damages and cannot be granted as a matter of course. It must be proved strictly. In this case, there is no evidence led to substantiate the claimant's claim for the sum for 2017 and 2018 arrears of salary. This is in view of the fact that the second defendant has evinced on Exhibit J, that is the statement of account, paid some monies into claimant's account, and the claimant failed to show the court the amount meant for purchases of foodstuff or those meant for his salary as he claimed. I therefore find that claimant's assertion that some of the money were meant for purchases for the defendants and not his salary was not substantiated. I find this lacking in his state in this instance, respecting the arrears of salary for the years 2017 and 2018, as the court cannot ascertain claimant's claim in this regard. It is in my humble view, therefore, that the claimant was only able to prove his entitlement to arrears of salary for 6.5 months in 2016, but failed woefully to canvass evidence to substantiate his claim for the remainder of years 2017 and 2018 claimed. By the case law authority of Ogunyaki and Oshoke and another citation captured, a court may, in a proper case, award less than is claimed, but should not grant more than is claimed. It is in consequence that I hold that Relief C only succeeds to the extent that claimant is entitled to the sum of 260,000 naira and not 820,000 naira as arrears of salary. I still find and hold.
Oh, please.
Is claiming the sum of 1 million naira as cost of action. The argument of the defense counsel is that it is unethical and against public policy for a litigant to pass on the burden of the cost of litigation to the opposing party. This position of the law has been altered by the Apex Court in the recent decisions, one of which is in the case of Kalpa and Alberto Nigeria PLC versus NDIC, citation captured. It was held in that case that a successful party is entitled to cost unless there are special reasons why he should not be deprived of his entitlement in making an award of cost. The court must act judicially and judiciously. The position of the law is in no doubt that a successful party is entitled to cost and same should not be withheld except with special reason. I find from the facts and circumstances of this case that the claimant having succeeded in this part of his claim and is thus entitled to costs. Also, I find that if the claimant was paid his salary as and when due, he would not have had to incur costs of his in the exercise my discretion in award of costs to the claimant. Consequently, I award the sum of 100,000 naira as costs to the claimant. I so find and hold. Claimant is 10% per annum for the arrears of salary owed and final liquidation of the judgment debt. This is clearly a post-judgment interest. By the provisions of Order 47, Rule 7 of the Rules of this Court 2017, it provides that at the time of making any judgment or order, the court may order interest at a rate not less than 10% per annum to be paid upon the judgment sum. Clearly, the provisions vest the discretionary power in the court to order as it deemed fit that interest at the rate of not less than 10% be paid upon any judgment sum entered by it in favor of the party. Since the power is discretionary in court, it is to be exercised judicially and judiciously, taking into consideration the peculiar facts and circumstances of the case leading to the judgment. So the case of Dokubo Asari versus Federal Republic of Nigeria, citation captured. The case of Sani and Angara, citation also provided. In this instance, in tune with Relief E, claimed there's a need to award a post-judgment interest of 10% against defendants in the event that they fail to pay the claimant the judgment sum within 30 days of this judgment. I so find and hold. Claimant equally by his Relief F, claiming the sum of 5 million naira as general and aggravated damages. The law is tried that where a breach is established, general damages will follow without need to specifically plead or prove the damages. See the case of SPDC Limited versus Nwabwezi, citation captured. The case of Felix George and Company Limited and Afinotam and others, citation also captured. It is well settled that once it has been found by a court that a party is liable for a breach of contract, award of general damages will follow. Such damages need not be specifically pleaded as they are not in the nature of special damages. In determining the quantum of damages to be awarded, the court is to exercise its discretion, taking into consideration the evidence before it. See the case of Ekan Afolabi. Just a minute. Afolabi. Yes, Ekan Afolabi versus Mr. Stephen Ola, citation captured. General damages are those losses that follow naturally from the adversary and is generally presumed by law as it need not be pleaded or proved, as I've stated earlier. General damages are awarded by the court to assuage the injury caused and act of the adversary. See the case of GTB versus Diodone, citation captured. Having held that the defendant's act of withholding claimant salaries without any just cause, claimant is entitled to some damages. I held in the case of Sally Udele versus Ajakuta Steel Company and another is an unreported suit number NICS/LKJ/15/2019, a judgment delivered on the 28th of October 2021, while considering similar issues thus. The ILO concept and agenda on decent work is not just about decency of work, but includes salary and payment of same as and when due, not in piecemeal or withholding same for months or years as done by the defendant's hearing. Hence, the law is right. The laborer is entitled to his wages not as at when able or desired by the employer, but must be paid at the end of every month as agreed by the claimant and the first defendant in his contract. The treatment meted out to the claimant by the defendants is demeaning against claimant's human dignity and thus offends the right of the claimants under Section 34 of the Constitution of Nigeria 99 as altered. This action, no doubt, affects his dignity as a father, husband, and in his social life, unquote. I place heavy reliance on the above reasoning in Dele's case supra by invoking the provisions of Section 254C, subsection 1, paragraph F of the Constitution as altered, Section 76 and 19D of the National Industrial Court Act 2006. These provisions enjoin this court in the exercise of jurisdiction to have due regard to good or international best practices in labor or industrial relations. I've earlier held in this judgment that withholding of an employee's salaries against ILO Convention 95, which is ratified by Nigeria due to the Nigerian Labour Act. The above reasoning is equally entrenched in the fact that considering the galloping inflation rate in this country, respecting the purchasing power of the current state of the economy, what 40,000 naira can buy in 2016, it cannot be the same as the value of what it can buy in the year 2022, almost 6 years after. It is in the light of all said that I find that this case is one deserving the exercise of my discretion pursuant to Section 19D of NICA 2006 by awarding 3 months' salary as damages to the claimant for withholding of claimant's salary for more than 5 years in the sum of 120,000 naira. I so find and hold. On the whole, claimant claims succeed in the most part. I therefore make these declarations and orders as follows. 1, that the defendant's refusal to pay the claimant his monthly arrears of salaries unlawful, unwarranted, wrongful, null, and void. 2, that the claimant is entitled to arrears of his salary in the sum of 260,000 naira only. 3, that the claimant is entitled to general damages in the sum of 120,000 naira. 4, that the claimant is entitled to 100,000 naira as costs. And 5, that the judgment sum be paid to the claimant within 30 days of this judgment, failing which it is to attract 10% interest per annum. Judgment is accordingly entered.
As called, please. We sincerely thank my noble Lord for the industry and the sapient decision. My Lord has indeed rekindled the hope of a common man in the judiciary. We are most grateful to your Lordship.
Very well. So you may pick up a clean copy anytime.
As called, please, sir.
Very well. The court will rise.
We thank you, your Lordship.
Industrial court.
From another court to this period.
There's no God of mercy.